The first case to come before us this morning is State of Ohio versus Francisco Vasquez. You have 15 minutes to present your oral argument. The State of Ohio has waived. When you argue, please understand that we do not speak of or mention the names of victims or any minors by name. We have read your brief and we are ready to proceed when you are.
Thank you very much, Your Honor. May it please the court, on behalf of the defendant, Attorney Justin Weatherly, we're here on an appeal, a very simple appeal on a motion to request a copy of the pre-sentence investigation report that was issued with regards to Mr. Vasquez prior to his sentencing in the lower court. Now, to begin, Mr. Vasquez was effectively denied his right to a direct appeal, even though his appellate counsel then, not me, not my office, correctly filed a precipice, a docketing statement, and a notice of appeal, all of which should have resulted in the pre-sentence investigation report being made a part of the record and sent up to this honorable court in an effort to appeal Mr. Vasquez's sentence. Because it was not included due to no fault of appellate counsel in that case, this honorable court was forced to deny the appeal and indicated so in its written decision, stating in no uncertain terms that because the PSI was not made a part of the record, the trial court's decision is rendered to be accurate, and no grounds for reversal exist. So the appeal was effectively denied due to what is described as nonfeasance by the trial court clerk. And then, of course, all of his other appellate rights then were exhausted. So now my office intends to seek alternative post-conviction relief. In order to do so effectively, we require the pre-sentence investigation. So we filed a motion requesting it, which the trial court denied. And the trial court denied it erroneously, in my opinion, based on 2951.03, which states that the pre-sentence report is only to be disclosed on direct appeal. However, that does not address the decision in State versus Johnson, which states specifically that when due process concerns are present, disclosure of a PSI is not constrained by 2951.03. And of course, due process rights are present in this case due to the fact that the court originally failed to follow revised code 2953.08 when they never disclosed the PSI to begin with.
Well, let me stop you there for a second. Didn't Johnson further say that on first appeal, in other words, it used that language on first appeal? I'm just curious as to how that affects your argument.
Well, obviously, we've got a different procedural posture in this particular case. Because in that case, as the case went up to the Ohio Supreme Court, the direct appeal had not been exhausted. Unfortunately for Mr. Vasquez, that's not the case here. By the time my office even was retained on this matter, the opportunity to appeal had effectively been lost.
So are you asking us to extend Johnson to include scenarios like you have here with Mr. Vasquez beyond the first appeal?
My apologies for interrupting, Your Honor. I would argue that Johnson opens the door in an appropriate interpretation of Johnson, simply allows for the simple reading of it that if you got a due process issue, then the constraints of 2951.03 do not apply. And we have a due process issue here. Essentially, we are robbed of any ability to provide post-conviction relief for Mr. Vasquez due to the nonfeasance of the trial court. And
Counsel, may I interrupt you?
Sure.
But you had another remedy, and for whatever reason, your client did not avail himself of that, and that is a motion to reopen the appeal.
And again, by the time my office was retained on this matter, Your Honor, that time had expired. we were well outside that 90-day time constraint. So our only opportunity would have been, at least for my office's purpose, our only opportunity would have been to ask this honorable court to extend that time. And to be honest, we didn't have a valid reason to do so other than we simply weren't retained on the matter until that 90-day time period had expired. Yes, because it is and the trial court did indicate that, but I would stick to my original argument that we're well outside that time period. So the original appellate counsel could have asked to reopen the appeal on the singular issue that the PSI had not been disclosed by the trial court and made a part of the record, and therefore the appeal should be reopened. But then you would have simply had to go back to the trial court again, because the appellate court would have had to have ruled that yes, the trial court should have included the PSI, would have gone back to the trial court. The trial court then would have included the PSI, and then at that point, sentencing could have been appealed at that point. And if the PSI had been made part of a record, then I could have obtained it as part of an appellate record and used it for purposes of post-conviction relief. By the time I'm getting this case, we're outside that timeline. So I've got two options. I can either ask this honorable court to file an untimely opening of the appeal, or I can simply ask the trial court to disclose the PSI and go direct to a motion for post-conviction relief. The trial court did not believe that there was a due process issue, denied my opportunity to review that pre-sentence investigation, and I'm appealing that decision based on the decision in Johnson & Johnson and based on the flat reading of 2953-08, which shows clearly that the trial court failed to do its job. They failed to give—
Counsel, what about the fact that we put that duty, whether rightfully or wrongfully, we placed that duty for the last 20 years on the appellate counsel to make sure that everything's part of the record?
So the fail-safe is on appellate counsel. You are correct, Your Honor, in stating that. But the law requires the clerk of court to transfer everything. And in fact, we cited that in our reply brief. The revised code unequivocally dictates that the trial court shall transmit a PSI as its pertinent part of the record. On the appeal of a sentence under this section, the record to be reviewed shall include all of the following: any pre-sentence psychiatric or other investigative report. That's straight out of 2953-08. So even though the fail-safe is appellate counsel, the statute still requires the trial court to act diligently and accordingly, and the trial court failed. That's nonfeasance, and nonfeasance isn't my word. That's the word of the Ohio Supreme Court. When the PSI is not included as part of the record, that is nonfeasance according to the Ohio Supreme Court.
So what do you need the PSI for a PCR? Because how do you get around res judicata? Because all this could have been raised on direct appeal.
Well, I would argue that should we file, for instance, a motion to vacate plea, that's something that's never been addressed before. So res judicata wouldn't apply. So let's say, for instance, Your Honor, that the PSI is released and it reads specifically that when asked to provide a statement as to the underlying offense, the defendant indicated that he did not commit the underlying offense, he's not guilty, and that he's only entering a change of plea because his lawyer told him to do it. Well, under those circumstances, the trial court judge shouldn't have accepted his plea in the first place. That would be clear evidence that the plea should not have been accepted and clear evidence that the plea should be vacated. And since no one has yet moved to vacate that plea, res judicata would not apply. And we actually believe that language very much is in there. A reading of the transcript of the sentencing hearing indicates that the reason the judge gave him the maximum possible sentence based on the plea agreement, a full 5 years on all 5 counts to run consecutive for a total of 25 years, the maximum possible sentence he could have received. The reason the judge issued that sentence according to the transcript is because the defendant failed to take responsibility for his actions. I believe the PSI is going to reveal the fact that he denies any wrongdoing in which
Well,
case,
let-
the trial court
Well, let
shouldn't
me
have-
ask you this. What's to prevent you from filing a motion to vacate?
I can file a motion to vacate. I absolutely can. However, the effectiveness of that motion to vacate is completely hamstrung to the point where I believe Mr. Vasquez's due process rights would be eradicated if I don't have access to a pre-sentence investigation where I can use the words of Mr. Vasquez indicating that he committed no wrongdoing.
Do you have the record?
We have the transcript of the change of plea, the transcript.
That's what I'm saying, the transcript.
Yes, we have that. But we don't have the pre-sentence investigation.
I understand that. That's what we're here for, but I was just wondering because in the transcript, it seems like it would have the defendant, if there was a colloquy, which if there wasn't a colloquy, that should have been raised on appeal too. If there was adequate colloquy, that would have gone over everything and he would have said that he was voluntarily entering that plea at that time.
So the pre-sentence investigation would have been conducted subsequent to the colloquy.
Well, I
So-
understand, but you're trying to use that to impeach the colloquy then?
Exactly. Because if the defendant can go into a courtroom and say, yes, your honor, yes, your honor, yes, your honor, over and over again, when asked all of the criminal rule 11 questions, and still not necessarily have a full understanding of what's happening. And evidence of that would be a subsequent interview with a probation officer where you're not in a courtroom and under that kind of pressure when the probation officer simply asks, hey, what did you do? And if the response is, I didn't do anything wrong, my lawyer told me to do this, that shows a clear lack of understanding of criminal rule 11 rights and a clear lack of an intent to actually enter a plea. And when this information is revealed to a trial court judge, a motion to vacate or frankly, a decision by the trial court judge not to accept the plea and not to proceed with sentencing is appropriate. But at the end of the day, Mr. Vasquez his appeal fell flat because the trial court failed to disclose the PSI, and certainly to your honor's point, appellate counsel failed to recognize that in a timely manner and raise the issue. The ability to reopen the appeal expired, and now we're left with potential post-conviction relief motions that are not constrained by time limits, but require the support of the pre-sentence investigation. If Mr. Vasquez truly did not commit the crimes to which he pled, and it truly believes he's not guilty, and there's evidence of that in the pre-sentence investigation, then we owe it to him from a due process standpoint to at least see what he said to the probation department prior to sentencing and be able to use that in a potential motion for post-conviction relief. There is no greater wrong than an innocent man serving prison time for a crime he did not commit. I believe that is possibly the case here. I think the pre-sentence investigation might reveal some evidence as to that fact. So we requested it from the trial court. The trial court erroneously denied it. We believe the Johnson case clearly gives us an opportunity to review it. We're asking this honorable court to reverse the trial court's decision and release the PSI. We're not asking this trial court to release Mr. Vasquez. We're not asking this trial court to reverse his conviction. We're simply asking this trial court to let us see if there's any post-conviction remedy available to him. That's all.
I'm assuming counsel did not request the PSI to be made part of the record in its original precipice that was filed in the matter.
The precipice doesn't offer a specific opportunity. There's no box that you can check that says, yes, I want the PSI or no, I don't. All it asks is that, do you want a full record? And the full record was requested. It simply wasn't included by the trial court. And since the record goes directly to the Court of Appeals and not to appellate counsel, it makes it very, very difficult for appellate counsel to notice whether or not something is missing. I don't want to speculate, but I would imagine that appellate counsel was probably as surprised to hear as anyone that the PSI was not included given the requirements of 295308.
Would he have had an opportunity to subsequently request the PSI? I'm trying to remember back from the days when I was on the trial court, there were oftentimes requests to supplement the record that were presented to the court. That's what I'm thinking about now, counsel, if you could help me with that.
Absolutely. So once a notice of appeal is filed, the trial court has 30 days within which to complete the record and submit it to the Court of Appeals. At that point, that record would be available for review by appellate counsel. And if appellate counsel notices at that point that there is a missing item, such as the PSI, appellate counsel can, in fact, move to supplement the record with the PSI, filing a motion with the Court of Appeals, at which point a ruling would require the trial court to include the PSI, and that was not done. So much to Her Honor's point, yes, the fail-safe is appellate counsel. That does not alleviate the trial court's obligations under 295308, but appellate counsel is the gatekeeper at that point.
Thank you for refreshing my memory on that.
My pleasure, Your Honor. Always happy to do it. If there are no further questions, I respectfully appreciate all of the time of Your Honors for allowing me to present my case here today. I don't have any further arguments to make, so I would rest on the merits of the briefs that have been submitted thus far.
Thank you, counsel. Perfect timing, by the way. Court will take the matter under advisement. We will issue a decision which will be mailed to both sides as well as posted on the Ohio Supreme Court website. Have a great day.